Now we'll discuss certain agreements which are considered as not opposed to public policy. So there are 5 such agreements, out of which the first one is arbitration laws or clauses for application regarding such agreement of foreign laws. So in that case, there is a leading case, and that was decided by our apex court or Supreme Court in 1998, and that is regarding transport shipping agencies versus black sheep shipping and others. So in that case, arbitrator was in Ukraine, and the parties agreed on application of Ukraine laws so it could be enforced in India, and there was no violation of public policy as the parties they have already agreed in that agreement regarding application of arbitration clauses and laws of Ukrainian law. And our second one is arbitrators residing in a foreign country, and regarding that important leading case, as it was decided by the apex court in MS Atlas Export Industries versus MS Kotak and Company in 1999, that arbitrators, even in foreign country, if the parties are willingly initiated the arbitration proceedings, and if it was applied by the arbitrators of foreign countries regarding any such agreement made between the parties, would not oppose to public policy. And our third important clause regarding agreements not opposed to public policy is payment in foreign country. And regarding that, one important leading case of the Supreme Court is MS Damania Industries Limited versus State of Odisha and others, 1998, where it was held that the tender for purchase of a plant and that payment regarding that purchase, and that is regarding foreign currency, is not against public policy, neither it is contrary to public policy, as already the agreement is made regarding payment in foreign country and also in foreign currency. And our fourth one, which is not opposed to public policy and such agreement, is that to institute a suit in one of the courts having jurisdiction. And regarding that, one of the most important leading case is that MS Thakural and Sons versus Indian Petrochemical Corporation Limited of 1994, and as it was decided by our apex court, and where it was applied under section 28, that legal proceedings and territorial jurisdiction of court decided privately under the agreement by the parties are not violative of section 23. So such agreements are not void, and these agreements are not opposed to public policy. And our last one is agreement to seize goods hypothecated and for auction of them So this was decided in the leading case of State Bank of India versus SB Shah Ali and others in 1995 by the Apex Court, where it was held that agreements made between the party regarding those goods which were to be seized, which are already hypothecated to any financial institution regarding any loan, and to recover such amount of loan by auction according to the agreement already made by the party and that financial institution, or agreements not opposed to public policies as per the terms of that agreement already which was reached in between the party and that financial institution. So, all those agreements that we have discussed, exactly we have discussed 5 such agreements which are not opposed to public policy as it was declared by our apex court or Supreme Court in those cases of 1998, 1998, so also in 1994 and 95, and all such agreements made by those parties are not opposed to public policy.